Hello students, today let us learn some provisions relating to Insurance Act 1938, control, amalgamation and winding up of insurance business. Objective of this lesson are to provide input to the students about the management of insurance business, to explain the process of amalgamation and transfer of insurance business, to enlighten the students with the concept and procedure of winding up of insurance business in India. Control of insurance business. The insurance company is managed by the board of directors within the framework of law of the land. More specifically, the provisions of Insurance Act 1938 and regulations made by the IRDAI. The IRDAI generally will not interfere with the day-to-day operations of the company as long as they comply with the norms of the law. Appointment of insurance administrators. Section 52A of the Insurance Act 1938 empowers the authority to interfere with the management of insurance business of a company when it finds that the business of certain insurance company is prejudicial to the interests of the life insurance policy holders. The Act permits the authority to appoint an administrator to manage the insurance business by prescribing the terms and conditions. Administrator discharges the quasi-judicial and administrative functions. The administrator appointed have a great responsibility to manage the business with greatest economy and efficiency. The administrator, after taking the charge of insurance company, shall prepare a status report explaining the conditions of the business along with his comments whether to continue the business or discontinue, with the reasons, if so, advantages or disadvantages of continuing of the business. The authority, after considering the report, shall take an action directing the company to stop or continue the operations or transfer the business to another insurance company on such terms and conditions which are beneficial to both the companies. The administrator may recommend for winding up of a company in full or partially. Depending upon the need and circumstances, the administrator may cancel the agreements entered by the insurance company with other companies. The administrator may take the possession of the property of the insurance company or party which is liable to pay the insurance company and pass order not to sell this same. The administrator has the powers of civil court and may summon the parties for deposing the evidence or statements before it and record. The administrator has the immunity against the actions of third party for the actions taken by it with a good faith, and no legal proceedings lie against him. Councils of Life Insurance and General Insurance. The Council of Life Insurance and General Insurance are the central bodies and associations of the insurance companies engaged in life and general insurance business and assist the authority in promoting the insurance business in India. The Council of Life Insurance. The Council of Life Insurance is a central body having the representative from every insurance company undertaking life insurance business in India. Every life insurance company having license to undertake the life insurance business in India shall depute or nominate its representative to the council. All the life insurance companies are members of the council. The Council of Life Insurance is managed by the executive committee, consists of 4 representatives nominated or elected by its members, 1 eminent person not concerned with the insurance business nominated by the authority, 3 representatives of insurance agents, intermediaries and policyholders, 1 representative from self-help group and 1 from insurance cooperative societies. The member shall elect a chairperson to head the executive committee of the Council of Life Insurance. The Council of General Insurance. All the insurance companies undertaking general insurance business are the members of the council, and every company shall depute or nominate to its representative to the council. The council is managed by the executive committee, which consists of 4 representatives from the members of the council, 1 eminent person having nominated by the authority, 4 representatives from the insurance agents, third party administrators, surveyors and loss assessors, and the policyholders. The executive committee is headed by a chairperson nominated or elected by the members of the executive committee. The executive committee shall appoint a secretary to exercise his powers and do all such acts as may be authorized by the executive committee of life and general councils. The important functions of the executive committee of the life and general insurance council is to aid, advise and assist insurers carrying an insurance business, setting up standards of the conduct and sound practices, and advise the authority in the matters of controlling the expenses of insurance business, to bring to the notice of the authority about the insurers who are acting prejudice to the interest of the policyholder of life and general insurance. In order to achieve the objectives, the executive committee of the Council of Life Insurance and General Insurances may work together and formulate a common strategy to minimize the expenses of the insurance business. Amalgamation and transfer of insurance business. Amalgamation of insurance company is the process of joining of 2 or more insurance companies, either to continue as one of the existing companies or to form a new company. It is this transfer of the business of one insurance company to the other insurance company as per the terms of the agreement. The amalgamation of the insurance companies may be made either by the insurers suo motu or at the initiation of the regulatory authority. The insurance company transfers the assets and liabilities of the company to the other company, and the company which has received the transferred assets and liabilities undertakes changes to meet the objectives of the amalgamation. The structure of the company, such as the constitution of the board, capital structure, organization and management, policies and strategies, etc., are redesigned and a new structure is formed. The process of changes taking place in the insurance company is known as the restructuring of the company. By means of amalgamation, a restructured insurance company is formed. Section 35 to 37A of the Insurance Act 1938 has the provisions of amalgamation and restructuring of the insurance company. The amalgamation or transfer of the insurance business has to be undertaken in accordance with the schemes prepared by the parties and within the framework of the Act, and such scheme is approved by the authority. Scheme of amalgamation and transfer of the insurance business of an insurance company. The insurance business of an insurance company other than life insurance business of the insurer who is domiciled in Indian but incorporated by any law other than in India can be transferred to other insurer by means of an agreement on terms mutually agreed, which are not contrary to the provisions of the Act. The parties to the amalgamation having interest and agreed upon the terms of amalgamation have to apply to the regulatory authority for the approval of the scheme of the amalgamation. The 2 companies should send a letter of intention of amalgamation to the authority at least 2 months before applying to the tribunal for approval of the scheme, and along with the 4 copies of the documents supporting the scheme. The books and documents will be kept for accessing of the policyholders at principal and branch offices of the insurance offices concerned. The scheme prepared shall have the terms of the agreement under which the transfer or the amalgamation is proposed to be effected. The documents accompanying the letter of intention to the authority include draft agreement or deed of the amalgamation, which contain the terms and conditions of the amalgamation, balance sheet of insurance company's business of both the companies as per the norms prescribed by the regulations, actuarial report of the insurers as required under the regulations, a report on the proposed amalgamation or transfer prepared by the independent actuary having no professional relationship with any of the parties to the agreement or as decided by the authority. Any other information required by the authority after the notice of intention is issued to the authority. The information provided should not be more than 12 months old from the date of intention of amalgamation or transfer submitted to the authority. The authority, after receiving the notice of intention of amalgamation, shall require the insurers to send the above available information to 25 policyholders of any class of insurance along with the nature of the scheme and related documents. The authority may direct the insurer to publish the information as per its direction, and the same is made available for a certain period. The information may be published to enable the interested parties to understand the nature of the transaction. The authority, after hearing the parties concerned on the subject of the agreement and terms of the scheme, may approve the scheme and pass the required orders facilitating the amalgamation or transfer of the insurance business. On approval of the amalgamation or transfer of insurance business should be completed within 3 months from the date of approval. The newly amalgamated and restructured company should submit the certified copies of all the financial statement, balance sheets, declarations and certificates in duplicate signed by the parties concerned to the amalgamation. The authority, after receiving the statements and information required, will guide the new restructured unit about the deficiencies of the amalgamation and direct them to fulfill the leftover provisions. The authority is empowered under the provisions of Section 37A of the Insurance Act 1938 to prepare a scheme of amalgamation on its own if it is satisfied that the amalgamation is required in the interest of the public, policyholders or insurance business of the country as a whole, or in order to secure the proper management of insurer with the written consent of the other insurer taking part of the amalgamation. The scheme shall contain the particulars of the insurer such as constitution, name and register office, capital, assets, powers, interests, authorities, privileges, liabilities, rights and obligations of the transferee, insurers, etc. The terms and conditions under which the transfer of insurance business is effected in favor of the transferee. The changes in the board of directors, appointment of new board of directors of the transferee. The extent of the interest of the policyholders, shareholders and creditors and their rights. Changes in the articles and memorandum of association of insurance companies, insurance contracts, cash position, allotment of capital to shareholders, settlement of claims filed by the policyholders, allotment of shares to the shareholders according to the agreement between the two insurers. Insurance products and schemes that are accepted by the authority. Employees, workmen, agents, authorities and other matters concerned to the scheme. The draft scheme may be changed at any time by the authority in the interest of the policyholder or parties concerned. The draft scheme has to be placed before the central government for approval, and the central government may approve the same with a or without modifications. The scheme of amalgamation has to be placed before the Parliament. If the policyholders or the shareholders has any grievance, may apply to the authority for settlement and payment of compensation. Winding up of insurance business. Winding up of insurance business is a process by which the operation of the insurance business is discontinued and action is initiated to consolidate the assets and liabilities of the insurer, arrange the settlement and payment of the liabilities, if any, either to policyholders or and to the employees or to any other creditor or to the tribunal if the dispute is pending before it. It includes the liquidation and dissolution. Dissolution of the insurance company is the end of the winding up. Winding up of insurance business is carried in accordance with the provisions of Section 53 to 64 of the Insurance Act 1938 and Sections 270 to 365 Companies Act 2013. Section 53 of Insurance Act 1938 confirms that the winding up is ordered by the National Company Law Tribunal. The winding up procedures are more or less similar to all types of or classes of insurance business such as the life and general insurances. The winding up of insurance may be voluntary winding up and winding up by the tribunal. Voluntary winding up, Section 54. Though voluntary winding up is permitted under the provisions of the company law and it is discouraged for insurance companies, but under the special circumstance of the insurance company, if the winding up is only the solution for the settlement of the liabilities of the insurer, the voluntary winding up of the company is permitted. The voluntary winding up is also permitted for the purpose of effecting an amalgamation or reconstruction of the insurance company. Winding up by the tribunal, Section 53 of Insurance Act 1938. The orders of winding up of the insurance business may be made by the tribunal in addition to the grounds stated in Section 270 of the Companies Act 2013, which are insolvency, non-compliance of provisions of the Companies Act and Insurance Act, default in submission of returns, reports, statements and disclosures. Continuance of insurance business is detrimental to the interests of the insurance business, interests and integrity of the country, policyholders and shareholders of the company. At the request of the central government and Insurance Regulatory and Development Authority of India, winding up procedure, Section 272 of the Companies Act 2013 and the Section 53 of the Insurance Act 1938 have laid down the procedure to be followed for winding up of the tribunal. A petition for order of winding up is to be made to the tribunal along with a scheme of winding up either by the shareholders of the company or the policyholders or the IRDAI or the central government at the request of the IRDA. The shareholders and policyholders are the persons having the interest in the insurance company. A petition to be filed by the shareholders should be signed by not less than 1/10 of the whole body of the shareholders or shareholders having shareholding not less than 1/10 of the whole share capital. In case of policyholders, the petition should be signed by not less than 50 policyholders holding live policies of life insurance that have been in force for not less than 3 years, and the total value of the policy should not be less than 50,000 rupees. The shareholders and the policyholders can apply to the tribunal specifying the reasons for seeking the winding up of the company. The insurance company should prepare a scheme for winding up and submit to the IRDAI stating the claims and counterclaims, obligations, liabilities and rights of the insurance company and other related parties in addition to the statement of valuation of the assets. The IRDAI on its own, after examining the returns and reports submitted by the insurance company, if found that the continuance of the insurance company is detrimental to the interests of the shareholders and policyholders, may request tribunal for passing order for winding up the insurance business. The tribunal, after receiving the petition along with the report on the affairs of the insurance business, it may either accept or reject or pass an interim order or appoint a provisional liquidator or order the winding up of the company. The liquidator so appointed may arrange to value the assets and liabilities of the company and take over the assets in the possession of the settlement of the issues and claims. The liquidator or the receiver appointed shall arrange valuation of the assets and liabilities of the company with the help of the appointed actuary as per the provisions of the Act. The valuation of the life insurance policy should be made as per the rates fixed by the actuaries appointed by the tribunal. The actuary appointed by the tribunal considers the purpose of the valuation, rate of interest, rate of mortality, and sickness, valuates the assets and liabilities of the insurer. The actuary also considers the special directions issued by the tribunal while undertaking the valuation of the life policy or any other policy. In case of general insurance policies, the assessment of the asset is made taking the last premium paid to the insurer and the time left before the maturity and proportionately to the leftover a period of the policy, and premium is calculated and valued. The tribunal has the power to reduce the value of the contract of the insurance of life policy when requested by the insurer and thinks fit that the reduction is reasonable. The valuation of the asset of life insurance policies ought to be calculated separately from the valuation of other physical assets of the insurance company, and if any excess of assets of life insurance is bound after satisfying the liability of the life insurance business, equal amount of liabilities are added to the life insurance business. A notice to be given to all the persons whose names appear in the registers of the insurance company about the winding up of the insurance business and distribution of the surplus amount over the liabilities, if any. When the affairs of the company have been settled, liquidator shall make an application to the tribunal for ordering dissolution of the insurance company. The date mentioned in the dissolution order shall be the date of closure of the company. Winding up of secondary company, Section 57 of the Insurance Act 1938. If the insurance company has one or more secondary companies and the winding up of the principal company is ordered by the tribunal, the winding up of the secondary company, unless specifically excludes from winding up, is also wound up. If one principal company has two or more secondary companies and the secondary company contains more than one principal company, the tribunal, if the secondary company is under the winding up, should hear the secondary company before passing order of the winding up. Any creditor or any party interested in the secondary company or of the principal company can file a petition to the tribunal for the winding up of the secondary company. If the secondary company has objections or grounds to avoid the winding up of the same, it can file its objections to the winding up, and tribunal, after giving a sufficient opportunity to the concerned and hearing the parties, can decide on the winding up. Partial winding up of insurance company. The partial winding up of insurance company is applicable when the insurance company has more than one class of insurance business, such as the life insurance or the general insurance. The winding up of complete insurance business is not necessary as one of them is functioning successfully. The insurance business which is not working properly is required to be closed. As such, a separate scheme may be designed for winding up. The process of partial winding up is same as that of a general winding up of the company. The tribunal on application shall accord approval for partial winding up. Appeal. The parties aggrieved by the orders of the tribunal may prefer appeal to the National Company Law Appellate Tribunal against the directions of the tribunal. Students, hope you understood the concepts and the process and procedures laid down in the lesson and also legislation.